A woman who said that she was raped as a child and was unable to have her case heard in court has been advised that her abuser would now be charged under updated guidelines. Emma Bryson, who was just 10 years old when the abuse started, was told that had her abuser still been alive, her case could go to trial. She's confident a change in how rape cases are corroborated will lead to more prosecutions. Katrina Renton has been to meet her, and a warning that you may find Emma's story distressing.
So I was sexually abused and raped by a family member, and that started from when I was about 10 years old and went on till I was about 14, which was quite a difficult experience. And it didn't just happen to me; it did happen to. I knew of other children who'd been also abused by the same person.
You raised it at the time, and it could never go to court.
No, so I reported when I was 14 the first time. And nothing was done. I was just told, well, there wasn't any evidence, so they weren't going to take it forward. And that was a really hard thing to do, was report it in the first place, because, the person that I was reporting was a family member. It was, it affected my whole family. It was a really, really difficult thing to do. I wasn't equipped for it, really. I found it really difficult to talk about what had happened, which I think is true of lots of other people who've had similar experiences. So that was difficult. And when nothing happened as a result, you just have to kind of bury it and, move on. There wasn't any opportunity for me to take it any further then. And it was many, many years later that I thought about reporting it again. And, having lived with it for all my adult life, I think I was better equipped to speak about it when I went back to the police again in 2016.
And when you went back to the police in 2016, the way the law was meant that you still couldn't take it further.
Yeah, and I didn't know anything about the law. I didn't understand how the law worked. I made the assumption that if I went to the police, that I made a statement, if there was any evidence available, the police would be able to use that evidence. And I also knew that there was evidence. So I knew there were social work records, there were medical records, lots of people knew about what happened to me. So I think I did feel quite confident when I went to the police and reported, and then it was... The investigation took about a year, and then they came back and they said, no, they weren't able to take it forward because the evidence available didn't meet the requirements of corroboration. And up until that point, I didn't even know what corroboration meant. I took it at face value and thought as long as there's, there's information to corroborate my account, that would have been sufficient. But what I was told was that corroboration under Scots law meant that very, very specific requirements had to be met. And in my case, the evidence didn't meet those requirements.
And you worked with Susie and Shirley and set up Speak Out Survivors and campaigned for a change in the law.
Yeah. So I initially, when I first got told that my case wasn't going to be prosecuted, and I then learned about what corroboration actually meant, and I was horrified. I just thought, how can this even be the case, that it is so difficult to get a case to court? And so that's really kind of what sort of set me on the path to trying to raise awareness of what corroboration actually meant, because I think most people didn't really understand it. I'd done some campaigning around engaging with politicians to try and kind of get a bit of support, and then I was latterly introduced to Susie and Shirley through Rape Crisis, and we then kind of formed a more coherent kind of campaign group, and we've been working together ever since.
And I suppose the culmination of that campaigning was that the definition of corroboration has now been changed in sexual abuse and rape cases. Tell me, what did that mean to you, first of all, to hear that change in the law?
Oh, amazing. I think it was something that myself and Susie and Shirley had been working towards for best part 7 years. To see that happen was momentous. And I think it's also important to say that for all three of us, when we started this campaign, it was never about... We never did so with the expectation that we would change our own cases. We did it because we wanted to make things better and easier for other rape victims in the future.
Your specific case would now have gone to court. Tell me about that.
So as part of our engagement with the Lord Advocate, which has been ongoing over the last couple of years, when the Lord Advocate's references were successful, I was given the option as to whether I would like my case to be reviewed, and Susie and I both had our cases reviewed. And again, that took quite some time. They have to go back and look at all the evidence again. It was a long time waiting, which was just as difficult. It would have been third time around for me trying to see an outcome. But then, yes, I was then informed that they had reviewed all the evidence in light of the Lord Advocate's references, and under the current definition of corroboration now, there was sufficient evidence for my case to be charged. However, the man responsible for what happened to me had died in the interim. So I felt vindicated, like all the work that we'd done for those 7 years, like it was worth it. We'd been right in our view that corroboration prevented offenders from being prosecuted, and specifically sex offenders, because corroboration is, as you'll be aware, it applies to all offences, but it's specifically problematic when it comes to sexual offences. So,
do you still think about what happened to you as a child, and has this helped you move on?
I do think about what happened to me as a child. I think the child that I was lives within me, always will. But that child helped me to become a really strong person, and someone who isn't afraid to speak out, and someone who's, I work very hard, have worked very hard to make a difference to other people who've had similar experiences to me. And the child that I was survived to become the adult that I am. And I'm really proud of that. And I think Susie and Shirley, would both say the same thing. And I have no regrets, absolutely no regrets.
That's Emma Bryson speaking to our reporter Katrina Renton there. Well, listening to that is Thomas Ross Casey, former president of the Scottish Bar Association, who's with me in the studio. Good afternoon to you.
Good afternoon.
Thanks very much for joining me. First of all, just clarify, if you will, what has actually changed now in legal terms?
Well, what's changed is that before a citizen could be exposed to many years in prison, being put on the sex offenders register, being separated from his children, we used to have a rule that there had to be two sources of evidence before the individual could face all those consequences. And we moved on to a different system where if the complainer, for example, is seen to be distressed, the fact that an individual saw the person in a state of distress, we now say constitutes a separate source of evidence, with the result that that's two sources of evidence.
Right, so effectively in a rape situation then, which I'm sure is very difficult to ever have a second source of evidence in terms of an eyewitness, because normally it's between, it's the accuser's word against the complainer's word, which I suppose is the difficulty in bringing a case to prosecution. And is that why this has been changed?
Well, I mean, it's not that difficult to bring a case to prosecution because there are thousands of cases prosecuted already. And actually, the two things which had to be proved by two sources of evidence in most cases are fairly easily proved, because in most rape cases, both the accused and the complainer agree that there was intercourse, and the question is whether it's consensual. So there are two sources of evidence in most cases. The difficulty in Emma's case was that was not the situation, and therefore there was only one source of evidence, namely her claim. And now, provided there was evidence that she was seen to be distressed at the time, under the new law, or a new interpretation of the law, to be completely accurate.
But the issue of consent is that's the crux of it, isn't it?
In most cases, that's the crux of it. So, not many cases. Well, we don't see cases which fail because of a lack of corroboration, because clearly they wouldn't be brought if the Crown didn't think there was sufficient evidence. I think that what will happen is that more cases which previously were marked for not to be prosecuted will now be prosecuted. And, I've had this discussion with people. It's not expected that there'll be any more convictions, because if they couldn't get convictions when they had two or three sources of evidence, I suppose in a general view, it's less likely they'll get a conviction when there's only really one source of evidence.
So despite this element of, the victim being distressed, giving that more importance as evidence in a rape allegation, does that... you don't think that will lead... Is it leading to more convictions? Is it leading to more prosecutions, at least?
It will certainly lead to more prosecutions as a result of the fact that we seem to be making a whole number of changes at the same time. Abolishing corroboration in any realistic sense, restricting defence practitioners from asking proper questions because they're disallowed by the court, doing away with the not proven verdict. I don't have the slightest doubt that there'll be more miscarriages of justice in Scotland as a result of these combination of changes.
So if it doesn't translate into more convictions, I mean, that is, I suppose, ultimately what campaigners would like to see. At the end of the day, people, always ask why there is such a low conviction rate for rape cases.
I don't accept there is a low conviction rate. There's no statistics in relation to...
Compared to other crimes?
Well, if you have multiple complainer rape cases, which form quite a high percentage of the cases, then the conviction rate is actually very, very high. And we don't keep proper statistics. When the Scottish Parliament looked for data in relation to conviction rates in single complainer cases, there wasn't any data to be had. The Crown Office had to go and try and find some by pulling out the files and doing it. So, to have this sort of discussion, I'll accept it. If somebody shows me the data and is able to make the comparison, I'll start accepting it. I don't accept it just because it's repeated constantly in the public domain.
Okay. Thomas Ross, thank you very much indeed for joining me. Thomas Ross, KC there. Many thanks. Now, the first new road bridge across the River Clyde in nearly 2 decades has opened to traffic.